Hello everybody, this is Aishley Verma, an intern with LEXIS and Company, and today in this video I will be dealing with a case named Pandit Parmanand Katara versus Union of India and others. Citation of the case is 1989 AIR 2039. It was filed in the Supreme Court of India. The bench consists of Justice Mishra, Raghunath and Justice Oza. Date of the judgment is August 28, 1989. If we talk about the head notes of the case, so head notes of the case are Article 21 of Constitution of India, Section 33 of Indian Medical Council Act 1860. Facts of the case are following. The petitioner, who claims himself to be a small human rights activist and fight for the good cause of the general public interest, filed this application under Article 32 of the Constitution, asking for a direction to the Union of India for every injured citizen brought for the treatment should instantly be given medical aid to preserve life, and thereafter the procedural criminal law should be allowed to operate in order to avoid negligent death and the event of breach of such direction. Apart from any action that may be taken to negligence, appropriate compensation should be admissible to the family. He appended the writ petition a reporter entitled "Law Helps the Injured to Die," published in the Hindustan Times. The said publication is in the said publication it was alleged that the scooterist was knocked down by a speeding car. Seeing the forcefully bleeding scooterist, a person who was on the road picked up the injured and took him to the nearest hospital. The doctor refused to attend on the injured and told that the man should take the patient to a named different hospital located 20 kilometers away from the authorized handle medical legal case. The Samaritan carried the victim, lost no time to approach the other hospital, but before he could reach, the victim succumbed his injuries. The Secretary, Ministry of Health and Family Welfare of the Union of India, the Medical Council of India and the Indian Medical Association were later impleaded as respondent, and return to the rule has been made by each one of them. On the behalf of Union of India, the Under Secretary of the Ministry of Health and Family Welfare filed an affidavit appending the procedure of the meeting held on 29th May 1986, in which the Director General of the Health Service acted as chairman, along with the affidavit decision of the papers relating to the steps taken from time to time in the matter relating to matters relevant in the application but confined to the Union Territory of Delhi were filed. A report in May 1983 submitted by the subcommittee set up by the Home Department of Delhi Administration and Medico-Legal Center and Medico-Legal Services had also been produced. So talking about the issues, so issues in the entire case is just one, that the status of medico-legal was to be discussed. If we talk about the judgment, so the court had following judgment. The complaint was allowed partly, so it was not allowed wholly but in parts. The court directed the opponent that the opponent shall carry out left out work as a brochure in flat number 403 in months time after mutually adjusting the date. Complainant was supposed to assist the opponent in giving access to the opponent to her work to be done, while failing to which the opponent shall pay rupees 1,27,650. If the work in said flat is not completed within 2 months from this order, the opponent shall pay interest at rupees 9% per annum. From the date of this order, opponent shall also pay a cost of rupees 25,000 to the complainant. So this was the compensation that was given to the deceased person's family, and further the rule was also amended. So this is it for today. Thank you so much.